Libel tourism is the name given to the practice of end-running the First Amendment by suing American authors and publishers for defamation in the courts of certain foreign countries. These countries have laws that often disfavor speech critical of public figures, countries with often little no or connection to the allegedly defamatory statements that gave rise to the suits. England has become the favorite destination of libel tourists from around the world, especially wealthy libel tourists from countries whose own laws are hostile to free speech. London has been called the libel capital of the world. England's otherwise admirable legal system attracts libel tourists for several reasons. Let me touch on the main one by way of introduction to the subject of today's hearing. Our Constitution's First Amendment usually requires a defamation plaintiff to prove the falsity of a challenged statement. The First Amendment is even more demanding when the defendant is a public figure, New York Times, etc. Plaintiff must then prove actual malice, proof that the defendant made the defamatory statement, in the words of the U.S. Supreme Court, with, quote, knowledge that it was false or with reckless disregards for whether it was false or not, unquote. Not so under the English defamation laws. Under English laws, presume the defendant is wrong. Places the burden of proving the truth of an allegedly defamatory statement onto the defendant. This draconian feature of English law, a long way from Magna Carta, has drawn criticism not only from defenders of free speech in the U.S., but also from the United Nations and even members of UK's own Parliament. The threat of English and other foreign defamation suits by libel tourists has not diminished since we introduced H.R. 6146. If anything, it has grown and will likely to grow stronger as the Internet continues to facilitate the free flow of information across national boundaries. Today's hearing will give members of the subcommittee the opportunity to address four main issues. First, what features of some foreign legal systems, especially England's, attract libel tourists? Second, how prevalent is libel tourism? Who are the libel tourists and who are their American victims? Third, does libel tourism threaten the First Amendment rights of Americans, and if it does, how and with what effect on public discourse about important matters of public concern? And finally, what should Congress do about libel tourism? As I mentioned in my earlier remarks, we passed this bill in the House, and the Senate never addressed it. To help us address these important and timely questions, we will hear from four distinguished witnesses. Our first witness will be Rachel Ehrenfeld, an author whose ordeal with libel tourism has helped bring this issue to the public's attention. Then Laura Handman and Bruce Brown, two prominent Washington media lawyers who will testify about matters concerning the threat of libel tourism. Finally, Professor Linda Silverman of the NYU School of Law, one of the country's foremost experts on the enforcement of foreign legal judgments in our courts, and we'll continue our discussion and hopefully suggest possible next steps. So we have comity, not the Bob Hope variety, but the legal kind, and threats to the First Amendment. Accordingly, I look forward to receiving today's testimony, and I now recognize my colleague, Mr. Franks, the distinguished ranking member of the subcommittee, for his opening remarks.